Any mention?
May it please Your Lordship. Your Lordship, I beg to mention item number 62, Your Lordship.
Yes, to the other side. Why?
After vacation, Your Lordship.
No urgency.
No urgency, Your Lordship. Your Lordship, similar prayer for item number 64, Your Lordship.
So these are small matters, correct? This Rajesh Hajong and or they are big matters.
Your Lordship.
If finish them before the year ends, you have 64. No objection.
No objection.
Very good. Yes.
Highly obliged, Your Lordship.
But please, Lordship, I beg to mention item number 67, my lord. This is regarding Akang Nukma, my lord. I have informed to the private respondent as well as to the JHDC council also.
Yes. After vacation.
Lordship. Most blessed, Lordship.
All can 64, even the other two, if they mention after vacation. Now,
Please, Your Lordship. I beg to mention item number 69.
both other side. No objection.
No objection.
After vacation.
Please, Lordship. Lordship, I beg to mention this item number 58, Lordship. We have some difficulty today, Lordship. We need to seek some more instructions. We need to seek some
Your
instructions.
child is done by someone.
Lordship.
Yes, sir. Lordship.
Why?
1 week's time, Lordship, maybe.
What her matter, correct?
Yes,
Your
Lordship.
1 week, okay.
Similar prayer for item number 59, Lordship.
Please place 1 week time to seek further instructions. Allowed lesser than 1 week. Yes.
Similar prayer for item number 59, Lordship.
59?
I've 59, Lordship. I've already informed the...
Any objection?
No objection.
After vacation.
Highly obliged.
Yes.
May it please Your Lordship. Your Lordship, I beg to mention item number 68.
No objections, Your Lordship. No objections.
If the petitioner?
Yes, Your Lordship.
After vacations? Okay, yes. But 2 weeks also will go.
Highly obliged.
Obliged,
Yes.
Your Lordship.
I beg to mention item number 70, my lord. Let it come up after vacation.
Why?
My lord. There is already some talk going on, my lord. There is every possibility of settlement, my lord.
It should be settled. If it,
Yes,
is it
there's
correct?
nothing left on this matter, but they have already agreed that the next ritual, which will be
sponsor it.
performed on the 4th,
You'll
together
spon-
will be.
No, the other one is sponsored. I don't know.
Your Honor.
The only problem you have to sponsor it. The other one.
Yes, as per the collection made from the Raj will do it necessary. It'll be done on the 4th of this month.
So that is different. That is different. But council settled.
Yes.
Yes.
After vacation, my lord.
Okay. After vacation, this matter also. Yeah, okay.
My lord, item number 45 also, my lord. Yeah, I'm making a mention on behalf of Mr. Jha, my lord. He is not in a
Mr. Khan?
Mr. Jha. 45. R Jha, my lord. After 1 week, my lord.
45.
45. Item number 45.
45 is the orders matter. Order list, right?
Oh, my lord. I'm sorry.
Yes.
Item
Yes.
number 1.
Please, Lordship. Lordship,
Yes.
this is the second round of litigation. So we are aggrieved by the Lordship, the order which is passed by the. What had basically happened is, Lordship, the petitioner, he ran a sawmill cum veneer in the industrial estate in Riboi, and the place where the mill was situated, Lordship, the MECL, they constructed supply power lines and was taken over without any compensation.
When?
This was in 2016, Lordship. Thereafter, we had approached this Honorable Court with directions to pay suitable compensation and for alternative land. And the direction was passed, Lordship, by this Honorable Court Coordinate Bench on 4/4/2025. Lordship may kindly see the operative part at page 46. 45. Page 45.
45.
Page 45. This is internal page 41, Lordship.
Yeah. Internal page 18.
Internal page 18 at the bottom, yes.
Yes.
Para 41. to assess and quantify the extent of compensation to be awarded to the petitioner, the District Collector Deputy Commissioner, West Jayanta Hills.
It's a Ripoy district.
I'm sorry, Lordship. I'm sorry, West Jayanta Hills. I'm sorry. It's in Kretirshi, Lordship. I'm sorry.
It's
Got
Joa,
confused
my
with the- Yes.
West India hits.
Direct to take on the task by conducting an inquiry, including an inspection of the affected portion of the unit of the petitioner, and after hearing the parties, to draw up the award due and payable to the petitioner. This exercise is to be completed within 3 months from the date of receipt of this order. Lordship, thereafter several correspondence were made, and it boiled down to a meeting, and thereafter, Lordship, we were asked to submit a detailed report on the losses that we have suffered. That representation, Lordship, will find at page 55, annexure 8, Lordship.
Yes.
On this, Lordship, we had submitted to the Assistant Commissioner who was there, and we have mentioned the details of the inspection and Lordship would see at page 57 onwards, we have given them a statement of revenue loss as per our calculation, Lordship.
Now what happened?
And thereafter, Lordship, we were waiting for some further communication. Nothing happened. Directly, Lordship, kindly have page 69. Then we wrote to the Deputy Commissioner, Lordship.
Yes.
That is at page 68, our representation. We wrote to them. And then they replied by way of page 69, Lordship, saying that with reference to the subject cited above, I have the honor to inform you that the estimate has already been forwarded to the Joint Registrar Listing, High Court of Meghalaya, via this office letter dated 3/7/25. And thereafter, Lordship, we have written again to give us a copy of that letter, and Lordship will see their reply at page 71. They have enclosed it, and the enclosed part is at page 72, Lordship.
Yes.
In pursuance to the order of the Honorable High Court and so, I would like to state.
So what do you want now? The money is paid to you. You received 31 lakhs.
Lordship, we have not received anything. How they have come to this amount also is not
I will
known.
have to take instruction on this.
They informed the Joint Registrar of this Honorable Court, whereas we were under the impression that they are looking into our representation. We had a joint
You asked me
inspection.
29 lakhs.
Lordship, we are asking about 2.24 crores, Lordship. We have submitted their thing and kindly appreciate since
Yes,
2016.
take down heard Mr. S. W. petitioner. Issue notice MSR calling is present on behalf of
Lordship,
1, 3, 4 and 5.
3 is
My lord, yes.
Who's for the state? Who's for the state?
My lord, I'll be appearing for the state, my lord. Because
What
I-
about the MEPDCL?
Which item is this?
state authority.
Item number 4 and 5, my lord, I believe this has been assigned to Mr. Kharwan Long, my lord. So I'll be
Who's
taking.
item number 4 and 5?
Which item?
I mean, respondent 4 and 5.
My lord. Mr. Kharwan Long,
MEPDCL.
my lord, was assigned.
MSR, where's Mr. Kharwanlang?
My lord, he's not available today, my lord.
I can see that.
My lord, I have no information why he's not here. So he's not here. So I
Mr.
have
S.
to come
W.
forward.
issue notice. MSR only is present on behalf of 1, 2, 3,
This one and there.
6 and 7.
This one, no?
No, there's no appearance on behalf of the respondents 4 and 5. Steps to be taken to fix notice upon the 2 respondents within 3 days. Doctor.
4 and 5, my lord.
The again, just after implications instructions that always and for appearance response 4 and 5.
Item number 2.
This is a family pension matter. Here the petitioner husband, while in service, he died. While in service, he died on 28, Lordship.
Died in harness?
Harness, Lordship, yes. And he was a government LP school teacher. But there are several representation, communication from the interstate department for the regularization of the service of the petitioner husband. That has
You
not been
never
done.
regularized
Not yet, Lordship.
entire service.
No,
When
Lordship.
was he appointed?
My Lord will find his appointment 1998, Lordship.
Where's the letter?
My Lord will find the
Letter of appointment?
There's no letter of appointment, Your Lordship, just a joining report.
my Lord joining report will be there.
It is accepted by the which department? School?
My Lord.
As a non-teaching staff?
No, this is he was a teacher, Lordship.
Okay.
He was a teacher. My Lord will find the proposal for regularization at page, Lordship. Page 17. This is written by the Joint Director, addressed to the Special Officer to the Government of Meghalaya Education Department, Lordship. Then afterwards there were several communication, Lordship.
When did he die?
Died Lordship. He died on 19 January 2020, Lordship.
19 January 2020.
2020.
And you had no pension till date.
No, Lordship.
What happened to his proposal for regularization?
His name was not applied in the list given by the that cabinet.
Because no detailed information was there.
No, Lordship. I have enclosed the list that has been approved by the cabinet, Lordship, with regard to the Ampati subdivision.
About
That has
list of cabinet. Yes, I heard Mr. S.A. Sheikh, the council petitioner, to notice MS Ailing was present.
125, Your Lordship.
125 of the notice. Your present acceptance we have 125. That's also MSB first half, first part number 6. So this certification construction. Peculiar case.
Much obliged,
How
Lordship.
come there's no appointment letter?
appointment letter. In advance, I could not annex. Is there?
Look for it.
Yes, appointment letter.
Item number 3.
Look from the department also. You have enough time after vacations.
Yes, Lordship. Then my lord pendency. Then if my lord make an observation, pendency of the writ petition shall not be a bar to process.
Oh, no, don't need for that. Once is.
Oh, yes.
Yes.
Please, Your Lordship.
Yes.
Your Lordship, I filed this application invoking Article 226, Review 227. Lordship, I'm approaching this Honorable Court, Your Lordship, for supervisory jurisdiction over the subordinate courts.
You have 227. You
yes,
have
Lordship.
other court.
Lordship.
You can't take. You can't put your feet on two boats. You have to either choose 226, 227.
Yes, Lordship, but the circumstances involved in the case at hand, Lordship, it's quite of a different in nature. So, Lordship, what
Now we have to
happened?
be very clear, Mr. Lingdo. You have to take a choice. Either you want to pursue 226 or you want to take record 227.
For 227, Lordship.
227.
Yes, Your Lordship.
Then you have to go to the appropriate bench.
Lordship, the matter of concern, let me apprise Your Lordship on the facts and circumstances involved. So, what happened, Your Lordship? The petitioner has instituted a suit. Lordship, I have the main respondent here, number 6, as well as the main defendant in the suit. So, what happened in the suit, Your Lordship? The private respondent, she contested the suit. However, the matter proceeded ex parte
Against them.
against respondent number 6 solely, Your Lordship. So, what happened, Lordship? And pendency of the proceedings, the matter proceeded ex parte, and judgment and decree was passed by the subordinate court. Lordship, the decree is that.
That's one number 2 is CM Noklau.
Yes, Lord.
CM Noklau.
Yes, Lordship. Now, Lordship, the matter involved here in the suit was decreed in my favor, and there was some
Then he's
person.
a pro forma defendant only in the suit.
Yes, Lordship. He's a
What
I
is
have
the
allegation
claim?
against the main defendant in the suit and the private respondent number 6 here.
Number 6 is whom?
It's a private party, Lordship.
Okay. But you're not a party in the suit.
No, Lordship.
But
She's the party in the
she's
suit.
defendant number 1.
She's defendant number 1.
Yes. Then
Now, Lordship, what happened during pendency of the suit is decreed in my favor. So the decree, so far as the observation of the subordinate court, the district council court, Lordship, is that the defendants jointly and severally, the heirs, assigned successor, men's agent, representative, so and so, claiming or through them, are hereby permanently restrained from interfering with the right, title, and interest of the plaintiff from the suit land. And that the person's agent, person claiming through the defendant, shall be evicted and ejected from the suit land.
Okay.
Now, Lordship, upon the decree being drawn, Lordship, I have filed an execution case. And the execution case, Lordship, I was handed over possession on the 25th of April 2025. Now, Lordship, on the day of the execution proceedings, Lordship, the state respondent were there, the district administration of Riboy, the BDO of Jirang, and the police in charge of Patarkma, and even through the SP, Lordship, they have knowledge of the execution. Now, Lordship, what happened during pendency of the execution, I was handed over of the entire possession of the land, and all other men's and assigns and successors and those representative of the private respondent, Lordship, they were evicted on that day, and I was handed over peaceful possession. And Lordship, pendency of payment of award by the private respondent in Lordship, there were multiple FIR filed. Now, Your Lordship, an
But
FIR was
there
filed.
a cost of 10 lakhs.
Yes, Your Lordship.
Then damage cost whatever.
It
Then
was not paid till yet, Your Lordship.
by
till present.
the,
And
by the respondent number 6.
respondent
the
number
defendant,
6.
yes.
So, Your Lordship, they keep on filing FIR.
Who first FIR?
Even under the direction of the respondent number 6, they file FIR.
Who's filing FIR?
There are some other persons being evicted, Your Lordship, third party. Those persons, they occupy under the direction of the respondent number 6. Lordship, that can be clear in page number 69, Lordship. This is the report of the police. May I read, Your Lordship? It's page 69. Also, during the inquiry, place of occurrence was visited and found that the land claimed by the petitioner is an area located on Umrit Umling Road, agricultural land and huge in area. Verbally learned that it's located in the bordering between Nongladau, Jalitham village. During PO visit, the foreign person so and so is learned engaging in cultivation of in the area, and on further inquiry, it's learned that Sri so and so that he cultivated the land of Sri Erulin, a resident of so and so. Erulin, Your Lordship, she's the main defendant and the respondent number 6 in the present writ. Resident of Padarkama, who used to pay the rent so and so in the field since
what happened
2004. Now, Your Lordship,
being disturbed.
Yes, Your Lordship. Now the SP gave a direction that they should execute a bond, and a bond has already been executed. Now what happened, Your Lordship? I came to know at a later stage on Thursday, Your Lordship, for the agency which I have prayed for Your Lordship to list the matter on that day. Now another complaint was filed which is not within my knowledge. Your Lordship, may kindly come to page 74. Now, seen prayers by the farmers.
How big is the land?
It's 4 acre.
4 acres only.
Yes. It's a paddy field, Lordship. It's the soil and all is very ripe. A paddy field of Sri so and so stated they are unaware of the land dispute between.
Where is that?
At page 74, Your Lordship.
Yes.
This is the order passed by the executive magistrate.
Where reading?
Page 74, Your Lordship.
To harvest the paddy fields. They are unaware of the land dispute. Let them harvest.
No, Your Lordship, Your Lordship, they have already been evicted and restrained. Now what happened?
When were they evicted? In April?
On 25th April this year.
The paddy?
That's what, Your Lordship, this comes to this present order.
You didn't sow it.
No, Your Lordship, actually so far when I have won the suit has been decreed, Lordship.
You didn't sow the paddy. You look at equities now. Let them harvest the paddy and take a bond. Let them go.
Your Lordship, they are being restrained from entering into my land. How can they enter again?
No, just for
Once,
let the magistrate say that, okay, under the
Your Lordship, but
let them harvest and take the paddy.
However, Your Lordship, that order has been passed.
Where's the order?
It's at page 75.
To take the paddy?
Yes, Your Lordship.
Then they've taken it.
Yes, they have taken it on Friday itself, Your Lordship. I have the instruction.
Then close.
Your Lordship, but the major issue and concern here, Your Lordship, which
now say the matter before the executive magistrate, correct?
Yes.
Yes. So the thing is now, if they have already harvested the paddy, then you execute a bond that they and bring to the knowledge that there's a case and that you already have a decree in your favor. And so this allowing them to live the paddy is only because they say they were not aware about the. And since they cultivated, it stands to reason that.
Your Lordship, even if the farmers are not aware, but the executive magistrate is aware of the decree. A copy has been supplied to the district administration
now,
on the day when the execution was executed.
The land anymore.
Yes, Your Lordship, but does the executive magistrate have the authority to pass such order, overpassing the judgment and order of the district council court, Your Lordship, which is a civil court of competent jurisdiction?
See what I had examined this matter. Anyway, see, look at the order. Present matter constitutes emergency within ambit of 164.8 PNSS. That's what he says. Standing crop is matured. If you delay in harvesting the paddy, these people will go without food.
Yes, Your Lordship, but the matter of concern and dispute in Nongladau village, Your Lordship.
Doesn't matter.
It matters a lot, Your Lordship. It's my land.
Divorce of your land which has been decreed in your favor. You forget it. You will issue directions that
Your Lordship,
you only agree with this order. Page 25.
75, yes, Your Lordship. Now, Your Lordship, another concern here that arises here, Your Lordship.
No, to take the paddy from them also.
If it may, Your Lordship, but I'm not coming to that point as of at present. But Your Lordship, now here,
if they
may I apprise you,
cultivating this land, see, these are landless people, right?
Your Lordship, they are claiming
they are cultivating this paddy by virtue of someone allowing them. When the land was in dispute, maybe they cultivated many years. Now they are not parties in the suit. Also, they don't know about the existence of the suit. The suit is ex parte against the defendant also. Now, when ex parte is so naturally decreed in your favor, Now it's been decreed in your favor. Now these people are not aware. Now they're cultivating, and the paddy is ripe. But how can we? Can't do this. Kind of
Your
justice.
Lordship, the matter of concern, the day when the eviction was
Have you
carried
filed
out,
appeal against this order, against the decree?
I'm the decree holder, Your Lordship.
No, have the other side
No,
filed
they have
appeal?
not filed. They have not
filed
preferred
such
any
party decree also.
No, Your Lordship, they have not. But Your Lordship, the matter of concern here, Your Lordship, there is an observation made in the order based on the primacy finding, Your Lordship, which is therefore based on the primacy findings and based on the report filed by the BDO Jirang, the court under section so and so hereby direct the harvest.
Why should they
standing
appoint Headman Nonglada as receiver also? Let them
Yes, Your
harvest
Lordship,
and
this
take
is
it home.
one of the concern, Your Lordship, because Nonglada is not a village, it's just a locality in Numsong. This is the matter and controversy which, Your Lordship, before this honorable court as well has made a highlight that there's no headman of Nonglado. So how can he be appointed as a receiver?
It doesn't matter. It's,
That is a matter of controversy, Your Lordship. And then otherwise, whatever the judgment, order and decree of the District Council Court, Your Lordship, it does not, they do not
lie
respect
for this
it.
court also. This matter until 226.
Let me take further instruction, Your Lordship, let the matter come.
Let them take it. Otherwise,
But Your Lordship, if that is allowed, a law and order problem will create
what law
every
for
now
them
and
to take
then.
the party? Then they can sign execute a bond that you take the party.
One has already been executed, Your Lordship, before the SP office. And how can the extreme magistrate now again pass an order
They
in
do
such
not
an...
create any trouble. Thing is that let them harvest, let them take it. That's all. You are just a decree holder. You got a
It's
decree
been
ex parte.
executed, Your Lordship. They've been evicted as well, Your Lordship, from the land.
Eviction is a different thing. If the standing crop there, which they've cultivated by all rights, beholds the law, so they should take it. Yes, next matter. Mr. S. Alingo, please up to obtain. Otherwise, we won't entertain that petition.
Item number 4.
Hello, Bash.
Connected matters, no?
4 and 6 are connected matters, my lord.
More?
4 and
4 and
6.
6.
4 is union's appeal, my lord, and 6 is by the contractor.
So, since both of you cross appeal, we set aside the order.
My lord, the claims have been upheld by the arbitrator, my lord.
It is only
And-
on
and-
the interest from the date of application of
You
interest.
are- you
only
are-
that.
I'm union
You
appeal.
only on the interest aspect.
Interest not in the rate, only with effect from which date the interest will be which amount. What will be considered as the principal sum adjust?
No.
Only
You agree with what in your appeal?
Only on that point.
And Dr. Mozika?
I've come against the entire order, my lord.
The entire claim. Yes.
But here the difficulty what has happened, my lord. Award was passed, they filed execution petition, and in the while proceedings of the execution petition, we have deposited the amount 2.5 crore rupees, my lord. Now, in the meantime, we file a civil revision, my lord. The then Chief Justice sent back the matter to the tribe, to the commercial court, my lord. And commercial court has passed this order, my lord. Now, even if execution is to be taken, now the amount comes to around 80 lakh rupees only, my lord.
So why did you deposit 2.5 crores then?
Because that time the decree was there, my lord. This is under
As
the old.
per the original
This is under
decree,
the
my
old act,
lord,
my
as
lord.
per the original decree.
40
the amount-
Act.
Nine-
It will
40
come to
Act.
80 lakh rupees, my lord, according to our calculation.
That is
Now,
as
two and a
per
half-
their version, my lord.
2.5 crore rupees has been deposited in court, my lord, and we are not able to get back the money, my lord, because of pendency of this matter.
They have
They
to
take this
approach
plea
the
every time, my lord.
Approach the
What plea? The interest?
No, well, they will refund the money because while executing, my lord, we have deposited the entire amount as per the original decree, my lord.
And what happened?
That has been changed, my lord. Now the amount has been because of interest
So what do you
calculation.
want today?
Well, Lord, let both the matters come up together, but only technical issue here is in item number 6 is our appeal. In that we prayed for amending the memo of appeal. There's just one minor thing was required to be added because the order has been passed in both the cases. Our 14 petition for making the award rule of the court, there is an order, and their petition on 30 also order, but the main thing is passed in that order.
We're in the lower court.
By the lower court. So only mistake was that by oversight in our memo of appeal, we just did not mention that case number. Though the order and everything is annexed. Only for that minor correction, only to add that case number in the cause title and the prayer portion, we sought from this honorable court permission to amend the thing. The amended memorandum of appeal has also come, my lord, because parties are from outstation. Only problem is here, The notary has signed with the flat seal, the affidavit and all are notarized, and there is no other issues. Notary has put his round seal in all the pages, but here the registry is not accepting because notary did not put his initials on all the pages. But I think in their system is the notary, they don't put their signature on the round seal.
Of course, you put the round seal.
Here they did not put. For that only
Then
it is not taken.
suppose you just
Yes.
get round seals from somewhere and start stamping here and there.
Yes, it has come from Delhi. They did not put the initials on the from Kolkata. It has not. They have not put the initials, but the round seal is there on all the pages with the date and the.
So you
signature.
want direction from the court registry?
My lord, if your lordship, just to minimize the effort, if your lordship permits, we can make correction in the original also with the initial, only to add the dates.
What correction?
Only they add the case number. That's it, my lord. There is no other change in the pleadings
Where
and
have you
prayer.
made the correction? Which page?
Only in the cause title to add the case number. That's it, my lord. And in the prayer portion, they add to add their case number.
The 96 will be 102, my lord. That's what they want.
Only to add the arbitration case number 102.
Okay.
Only that. If your lordship permits, to avoid further delay,
Yes, Dr. Mojika,
we
I
can
don't think
just add that number in
it's not
the original thing.
You won't change the nature.
Nothing is changed in the pleadings and prayers.
Prayer, there's not even mentioned in 96 also.
That is what we just need to add that 102.
No, let's see the order first with regard to allowing when corrections allowed to be made.
Your lordship had allowed us to file the
Which
amended.
date, which order?
Which was the order?
5th of September.
You want to make by hand?
Yes, well, with the initial only to add in the cause title in the matter of, along with 96, case number 102 to be added. And in the prayer also along with 96, case number 102. Because the operating part of the order is passed by the court in the 102 petition.
You have the order.
Courts
Along correction.
on 1311, your lordship had allowed us to amend it. 1311. 25, your lordship allowed us to. Where is the petition?
Yes,
Where is the petition for?
today the matter is listed for filing of amended memo appeal. It is submitted by the learned senior counsel MS so that the correction in fact is very minor and is only to insert the number of a case that has been left out due to oversight in the cause title. In the cause title only.
The cause title and the prayer.
And in the prayer of
Add
the
that case
memo
number.
appeal. She submits that to expedite the matter. She may be allowed to make the correction in the registry. In the registry by duty itself.
Yes.
Yes, Dr. N. Mojika, counsel for the respondent, has no objection to this prayer made by the by the counsel for the appellant. Accordingly, next paragraph, in view of the circumstances and interest of justice, the corrections permitted to be made. Corrections will be made before the registry by today itself.
Yes.
But the main matter has to be heard, my lord.
List when?
Because
On
it's more than
third,
6
my
months.
lord?
One listen
Third
before the
time
vacation.
After vacation.
It's a short matter otherwise.
When?
I'm here.
On third, if your lordship permits, or otherwise after vacation, my lord.
Third, I'm okay.
After vacation. Third, this week's not good.
But only one observation lordship can give, my lord. The execution proceedings should proceed, my lord. They're taking the plea only pending of this matter. Execution should not be held up because of the only.
Doesn't matter, you're the union. You can wait now 1 month.
Already the matter is heard before the before the executing court. It's pending for order, my lord.
We'll go to February, March. My lord.
This matter has
And
been
our
argued
money-
before
our
the
money is stuck-
executing
our
court, my
money is
lord.
stuck, my lord.
However, it's submitted by Dr. M. Mojika that in view of the pendency of this matter, the execution proceedings are not progressing.
My lord.
So, is there any stay order against
No, my lord, executing court has already disposed of the execution after full payment. Execution has been disposed of.
My lord,
Now they have
after
filed.
that, the decree has been reversed, my lord.
No, but then where's the application for withdrawal of,
We have-
of that excess amount that you deposited?
It is there, my lord. They are taking a plea there, my lord. They have
But you have not filed it here.
They have to refund the amount.
And how can we pass orders or some? There's no application here.
But
I thought that you had made a miscase something.
But I'm only paying that pendency of
My
this
lord,
matter.
we have also filed an application for interim stay of the order, my lord. Since there is a counter appeal also, that matter may be stayed.
Refund the money. They're
Unless
taking
you file
all
a
kind of
miscase,
technical
Dr. Mansika, it's very difficult. We have to pass specific orders on specific application. Yes. We'll list for hearing. We'll list it on 11th.
My lord, 11th will be I'll be out of station,
Why?
my lord. I have a fixed hearing in Delhi High Court on 10th, my lord. So 11th I won't be able to reach it.
Okay, we'll have it on 9th.
9th I'll be traveling. If it's on the 8th or 3rd year, my lord.
8th. We'll try to complete.
Okay.
If they see, put in this application. Otherwise, yes.
Item
Yes,
number 5.
For further orders.
Obliged, my lord.
But we honored the decree, my lord. We deposit the money now.
That doesn't matter.
When it's time to refund the money.
Where can the court see that? Yes. Yes. Who's for the petitioner? Yes, MS Black.
Lordship, I'm praying for some accommodation in this matter.
Why?
Lordship.
This is not for hearing today. What's for today?
It is
Admission
lordship.
hearing.
Admission hearing, lordship. It is
7I.
7I.
Yes.
Lordship, past 1 year this case is pending. Last they filed in
Just
the
for 7I.
Just for 7I.
For segregation of 14B and 7Q.
Yes, Your Lordship.
Where is the judgment that Mr. Sen had given last time? Where's Mr.
That's
Sen?
our court textiles.
Your Lordship, due to some personal difficulty, Your Lordship, praying this matter may be adjourned for the day.
Only for this case he has possibility to
Yes.
appear.
Lordship.
Okay, very fair. What to do?
When Sir Sen will be available, Lordship. Lordship, actually, Lordship can understand. We are also under, though we are a government.
We are here
department,
only to dispose of the matter.
Yes, Lordship. We are also under compulsion.
We
Just
on tentative view also you filed an appeal, but even then,
Lordship,
but Mr. Sen said that he has
Listed on the 4th.
for this.
Lordship.
Yeah, problems on the 4th.
No, not on the 4th, Lordship, but subject to Lordship availability, Lordship. Because if on the 4th, then because Thursday, Lordship is to be little bit packed up, Lordship.
Yes.
Thursday.
So after
is-
vacations then.
Lordship, it's too long,
Once
lengthy
it's
matter.
Lordship, the interim order may continue, Your Lordship.
Isn't Trimota also?
Yes,
Enjoy it then.
Lordship,
Yes.
here
Order to continue the next date.
they are taking the plea of interim. They got the
This is
interim.
Loreto? Oh no.
No, it's Nehu, Lordship.
Okay.
Item 7.
On a prayer of some sort, yes. So all you do this matters.
My lord,
Today?
my lord, I'll pray for some accommodation for today because my file back has gone to Northside, my lord. By mistake,
He has too many vehicles.
that bag was put in another vehicle. That vehicle
has been hijacked or they
kind of, my lord, because early morning today the vehicle had gone to Northside, my lord. It was put in that particular vehicle. I was supposed to bring that
first
vehicle.
time I heard this kind of excuse.
No, it's not an excuse, my lord. That was put in that vehicle. I was supposed to bring it to court today, my lord. But that vehicle has left to Northside in the early morning, my lord. So it's already there now. Any day, tomorrow, day after, any day, my lord. Just for that.
It's not for me, it's for the it's for you,
Urgency in these matters, my lord, because we are spending nearly 15 lakhs a month, as I said.
Today is the first.
Yes.
We'll try on the third then.
Third.
Well,
As the files containing, should we record that? No. Yes, due to personal difficulty of the counsel for the petitioner, this is matter on third. Kabiang from case then? Huh? Yeah, no.
Tomorrow, Vishal.
3, 4, 8, any day.
Tenth.
Again,
10th.
No.
I'm also one of the petitioners, Your Lordship. Item in WPC 269 2005.
Yes.
Hello.
42.
Learned AG is appearing for the respondents.
Where is he? He's in town.
No, Your Lordship will be appearing through VC.
Where is he then?
Your Lordship, may I be excused?
Yes?
But because they're raising the question of maintainability, so they'll have to open.
There are serious questions. There's nobody about maintainability. There are serious questions because how you overcome that.
Malad, may kindly have the Representation of People's Act for a moment, Malad. Because the rules, the District Council rules, Malad, the provisions of the RP Act is paramateria, Malad.
Where's okay, take up the other matters first.
Can I have it after vacation?
For the time being, till after vacations.
I'll just point out, Malad, because section 137.
After vacations on the prayer of on the petitioner due to the absence of the.
Your Lordship will be appearing.
Where?
Your Lordship may be at the end of the board.
Just holding the court to ransom.
My apologies, Your Lordship.
Will impose costs then. How much cost will the government be willing to pay?
44.
Yes, sir. This challenge has been in the instant matter. Challenge has been made to maintainability of the writ petition. Stop. However, the matter is taken up. The learned AG is not available. Who is to lead the arguments? In view of the matter, let the matter appear after winter vacations. Yes.
Look, the
All right.
important issue in this matter is that section 137 of the RP Act has been repealed in 1965. However, in the rules, it still exists. So that is the issue.
44.
Yes.
Yes, Your Lordship. Lordship, I pray that this matter may become end of the board, Your Lordship.
What's the matter about?
This is regarding the release of pensionary benefit. I was died in hardness, my husband. And
No. Why you want end of the board?
Because my senior is still on legs, Your Lordship.
Because it is clear they have issued a sanction also.
When payment can be made? Must have instruction.
Your Lordship, that it come end of the board, Your Lordship.
It be paid by end of the board. End of the board. After some time. Yes, follow the
45.
You wait, the matter will be called out.
But I pray for 1 week time, my lord, on behalf of Mr. Jha. He's not.
You know, see, this matter will be infructuous now because
Release is over.
Release is over.
Mr. Jha is not well.
Yes, ma'am.
After vacations on the prayer of the council for the petition.
You will see this, it will become infructuous and
Six.
it will be,
Mr. Jha is not here. What will we do?
so then it will be after a week, not
Yes. What can we do? Well, after 1 week.
after a week.
After 1 week, after vacations.
After a week.
After 1 week. Yes.
46.
My lord.
In this matter, we have filed the objection.
Which objection you
My lord,
filed?
the objection is in respect of my missed case, my lord. I represent respondent number 12. So matter was supposed to be heard today. My lord, I'm praying for accommodation today.
Lordship, I have
ready?
similar prayer, Lordship. Since senior counsel is not available, Lordship.
I'm praying, my lord, on behalf of Mrs. Shulai, who's on bereavement, my lord. Mrs. Shulai, my lord, he's representing 12. He's on bereavement, so my lord.
After vacations. On the prayer of parties.
46 and 47, my lord.
48.
But this matter can be disposed of. If your lordships may kindly have the affidavit filed by the state.
No rejoinder necessary?
No. Similar matters have been decided, my lord, on other issues. However, this particular person is yet to be regularized. If your lordships may kindly have page 2, para 4, my lord.
Yeah.
Second paragraph of para 4, my lord. If I may read, my lord.
Yes.
The petitioner was appointed on 6th December 1991 prior to the cut-off date of so-and-so fixed under by the government policy for one-time regularization. Earlier in the year 2024, proposal for his regularization by the personal department from the so-and-so
However, on examination, it was found that relevant documents pertaining to the proposal was not submitted, and Health Department was asked to furnish relevant documents for further examination. Consequently, Personnel Department has just received the proposal for regularization in March 2025, which
is he still living or is deceased?
my lord, he is retired.
Sorry, retired.
Retired in September, my lord.
September.
Yes, my lord. And from information from the Personnel Department, my lord, his file has been cleared. So it's only the
We'll close
cabinet.
Yes,
Time frame may be given, my lord.
Yes,
and
Mr. Philemon Nongri, the counsel petitioner, submits that in view of the averments made in subpara under subparagraph to paragraph 4, the writ petition can be disposed of inasmuch as the matter is under active consideration by the respondents. Now, for the sake of convenience, the said subpara is reproduced here in below. Mr. S. A. Sheikh, learned come advocate, also does not exceeds also concurred submissions of the learned counsel of the. What is this?
my lord, on other issues, my lord, in the writ petition, similar orders may be passed, my lord. With regards to ACPS and pension, my lord. Similar matter, my lord. This person had also retired.
Object to the proposal writ petition at this stage itself. It's further submit. However, Mr. Philemon further submits that with regard to other entitlements, so the same also may be examined in conjunction with the process of regularization of the writ petitioner.
The time frame of 6 months, my lord.
Accordingly, in view of submissions and a statement affidavit made by the state respondents, the writ petition is closed with direction that the state respondents will consider the case of petitioner expeditiously for entitlement of pension, organization,
MSCPS,
and other service benefits, including benefits as may be admissible, preferably within a period of 6 months from the order.
Deep
matter all these hands closed.
Awesome.
49.
Please, Your Lordship. So in this matter, last opportunity was granted to the respondent number 6 to file their supplementary affidavit.
Please, Lordship. Lordship, I pray that this matter may be also come end of the board.
And we have who's these people? Hito will ask them to appear in person here tomorrow.
50.
No affidavit file. You have not filed. Then there will be serious repercussions. Where's Mr. Deb? Why you not file affidavit?
Lordship, I'll file it in the course of the day, Lordship. It's just been waiting for signatures, Lordship. I'm filing it in the course of the day. We have got the constitution and everything, Lordship.
When was the constitution made? After the case
21.
was filed?
No, 2021, Lordship. Today I'll file my affidavit today.
You want to see what is the objectives of your organization?
Lordship, I have enclosed it, Lordship.
What is this, a mushroom organization?
Absolutely not, Lordship. And in fact, just for the sake of reputation, Lordship, we had nothing to do in this entire decision making.
So since you're allotting the leases also there?
Lordship, nothing of that sort. I'll file it in the course of the day, Lordship.
List after 1 week. Mr. S. Deb submits that we can close it. This after 1 week. Yes, for further order. Yes.
The HCDC is also yet to file their affidavit.
You not file affidavit. Why?
Just for them to.
Yes, so we have to see what is the what do you call a nexus between NGO and a constitutional body, whereby on the pressure of NGO that validly entered lease is terminated.
Lordship, in my humble submission, we had not exerted a single.
But that's the reason given.
Lordship, that is why they have
to. That's why is this court so concerned?
Lordship,
why would we concerned if the normal termination of lease we have nothing to say?
Lordship. That is why
because of the pressure exerted by you as the NGO.
Lordship, I understand. I appreciate, Lordship. That has taken us as a surprise as well, as much as they has taken them, perhaps. That is why the district council affidavit is.
Yes. Where's Dr. Mojika? See, almost you need an affidavit also. On what?
And it's not a case where we were called or we had any meeting where we told them nothing, Lordship.
Strange case. Yes. Why no affidavit is forthcoming?
We'll file with revocation.
Revocation. Let's listen next week. Let's try. Yes.
I'll file it today. My supplementary.
That's up
50.
one reading. Yes, published. Yes.
May I please, Your Lordship?
With the
Praying for
affidavit.
some time, Your Lordship.
Why?
We've not received instructions.
Non-payment of salary, my lord. They have not been paid from
School
since
teacher?
last- No, my lord. They are working as a roller driver and handyman, my lord, in
Oh.
PWD department, my lord.
DRDA?
My lord.
DRDA? Which in the scheme?
PWD department.
PWD.
When can you file it?
Your Lordship, 2 weeks' time may be given, Your Lordship.
When was it filed,
It's
matter?
a fresh matter, Your Lordship.
1710. Yes. MS, I think what today I can renew a prayer for affidavit stuff. As a matter concerns non-payment salary is expected the next day the affidavit should be on board. Just after 2 weeks. Yes.
Much obliged, Lordship.
51.
May it please, Lordship.
You are not well, Mr. Pandey?
Lordship. Yes,
You are
Lordship.
not well.
Lordship.
Yes.
May it please your Lordship? Your Lordship, praying for a week's time to file an affidavit.
Lordship.
Ready? You got instructions?
Yes, Your Lordship.
Yes.
Lordship, Lordship, of course, even if they file Lordship, affidavit, Lordship, they cannot undo the fact that they have not reviewed the suspension before expiry of
Yes.
this, Lordship.
You have not reviewed it. What are your instructions? That is why I was going to ask. Have you reviewed the suspension after 90 days?
The instructions are with Mr. Sen, Your Lordship.
They're not specific?
The instruction are with Mr. Sen, Your Lordship.
Where's Mr. Sen today? He didn't come to court.
He's not available, Your Lordship.
Even you don't know where he is.
No, Your Lordship. So,
Difficulty is, Lordship, I'm
this
retiring
matter
on
may be
30th of
listed
December,
on-
Lordship.
This matter may be listed on the 8th, Your Lordship. In the meantime, we'll file an
Listed
affidavit.
tomorrow. Yes, just inform Mr. Sen. As there's some urgency in the matter, this is matter day after tomorrow.
Highly obliged, Your Lordship.
52.
Yes, come with instructions, whatever instructions you have. You need to file affidavit also. Yes.
Your Lordship, the state respondent is supposed to bring instruction, Your Lordship.
Where's Mr. Khan? What's the matter about?
Your Lordship, this matter, donation of land to the PSC department, Your Lordship.
Yes, Mr. Ibrahim.
He's on like before another court, so if this matter can
What instructions has he received the instructions?
Actually, I'm
No idea.
handicapped, Your Lordship. If this matter may come up after next week, Your Lordship.
No, it is just first time it's come. Prayer for the time is made by Mr. Abraham, Dublin GA, and it's a matter of 2 weeks.
Highly obliged, Your Lordship.
53.
For instructions, yes. For instructions to affidavit. Yes.
Lord, I'm praying for 5 months time to clear the pensionary.
time?
5 months time.
Usual order 5 months.
Connecting with 54.
54, similar.
Yes, 5 months.
55.
My lord, as per the last order, we were supposed to come up with instruction. My lord, if this matter can be taken up on Thursday or Friday, my lord, Mrs. Shulai will be joining by that time, my lord.
Only one thing is yes, as the learned AG is not present, submit this matter on Thursday
My lord.
for instructions.
My lord.
There's only when was that notice issued?
My lord.
That was given to small work orders.
56. 56.
This is also a pension matter.
5 months.
5 months. Much obliged.
Yes.
57.
Yes,
Government need to get the instruction order is supposed to
Yes,
file
MS
the
Lalu.
as per the last order, Lordship.
Fresh matter.
Yes.
None appears, no government advocate.
We've given 2 weeks time to file our counter, Your Lordship.
You're appearing?
This Lalu is appearing. He's
Not in station. Yes, as paid for the 2 weeks time allowed for affiliate instructions.
highly obliged, Your Lordship.
Second call 44.
Yes, why you
Lordship, we have received instruction.
When can you clear
Lordship,
it?
the only difficulty is that if Lordship would see the annexure 4, page 15, Lordship, the sanction was made after the employee passed away. This was in April 2025. Thereafter, no one has approached, Lordship. That is our instruction.
What is this, Mr. Sangma?
And there is no representation
the
also.
Died, this person,
Yes.
Albina.
No. Albina is the wife. The sanction order was issued in the name of the deceased employee. And thereafter, no one has approached.
You go and approach.
Let them with
No,
a.
Lordship, we have approached Lordship. That is
Where?
actually we did not write the
Show
application.
some documentary proof that you approach.
We are just asking for a succession certificate and a formal application. We'll process it, Lordship.
That certificate is not
You want to short circuit the
necessary,
process.
my lord.
Why is not necessary? She is nominee.
Yes, it was in the service.
service- where's
It's your
service-
wife, the petitioner.
Is it
Usually for the wife, it's
No,
not required.
where's the?
We have enclosed the marriage certificate
No,
also.
suppose he has more than one wife. What happens?
No,
all the
no,
cases
there is
here?
only one wife. There is no
One
other.
fine day,
person
one
claiming.
wife says, and then a matter comes for review. Appeal, leave.
He has not made a
appeal,
representation
got two
also.
wives, three
Lordship,
wives.
in that case, there maybe dispose with the direction that we will appear and within the time frame let him dispose.
We don't want to issue directions like that. We won't approach first. We'll keep matter.
There is
pending.
no representation also. Let them
Lordship,
get the.
within 1 week you will approach it, Lordship. Let it matter be.
Take down then. This writ petition has been filed seeking release of these are gratuity.
This is gratuity and leave salary arrears.
Gratuity and leave salary arrears of the deceased employee who is stated to be the petitioner's husband.
Lordship.
Stop. It is noted that an amount had been sanctioned on 22nd April 2025. Stop. Next paragraph. Mr. S. Deb, however, submits that as the employee, as the employee has since deceased, it is necessary that the petitioner, if he is the legal heir, as claim approach the district council authorities with proper proof and authority
of succession.
Stop. Mr. P.T. Sangma therefore prays that he will not withdraw his application and to allow the petitioner to take necessary steps in this regard. Yes. Accordingly, prayers allowed, that stands withdrawn, allowing the petitioner to approach the authorities with proper documentation and proof.
Maybe liberty may be given also at the same time we file it.
That's what you liberty to do whatever you want. Matter stands as both of it.
Otherwise, my lord, succession is not required actually.
You should do them. You're not
prove any proof of
put nothing here. No, you've gone there. You can compel Mr. Dev.
Lordship, only maybe that we will
Enough,
approach.
yes.
No need
Next.
to mention the succession certificate. Lordship, only that
I
part.
didn't mention succession. We said proof and authority. Yes.
Yes, authority. Only marriage certificate will produce.
Yes.
Lordship. That succession. certificate. Much blessed.
Hearing
Lordship.
60.
So this was the matter where we agreed by the extension of the tender, Lordship, for a period of 2 years, when the original tender itself was for a period of 3 years, Lordship. And this, it appears, Lordship, that this is the only situation wherein this extension clause was there, Lordship. We have enclosed other tenders for the same work. There was no such extension clause, Lordship. Even in the tender document and the terms of the tender, it was for 3 years. Conventionally also, it has always been for 3 years, Lordship. Only in this case, it appears that after the tender was accepted, before the agreement was signed, Lordship, it was on the request of the
lessee
himself that an extension clause was incorporated. And extension also, in my humble submission, Lordship, extension should be for a reasonable period of time, Lordship. For a tender of 3 years, extension may be for 6 months.
How is convention enforceable, Mr. Dev?
Lordship, my humble submission is that at the end of the day, Lordship, since it involves...
And it is not an English court where conventions are enforceable.
Lordship,
He has only statutory violations or violations that are enforceable.
Lordship, my only humble submission is that, Lordship, that when the tender condition itself provided for a, did not
2 years.
for any indication that there will be an extension, how they could not have...
When is the next year coming to a close?
Lordship, this is...
When is this extension coming to close, rather?
June of next year, Lordship. 23rd June next
It's expiring.
It's expiring, Lordship.
Then
And we were desirous to, this was been extended, Lordship, for 2 years, Lordship.
from
Originally signed in 21
to 23.
to 23, and then another 2 years, Lordship. And the reasons, Lordship, they have put the reasons on COVID and so and so. Those were well known at the time of bidding only, Lordship, in 2021.
Yes.
And especially when the tender.
Let's see, this is 25th December. When was the extension done? Let's see the extension. Extension letter.
Lordship, the extension is there at page 68. We were awaiting for a tender. We filed for application through Archival.
Now in the agreement clause, there was a provision for extension. Where is that? Let's see first.
Lordship, that clause, Lordship, can find the agreement starts
the agreement?
from page 59. Sorry, 60. Page 60.
60.
And Lordship will see the extension clause at 64. Clause 17. Lordship.
17.
Page 64, clause 17.
That decision to extend the tenure of this agreement shall be the sole executive and absolute prerogative on such terms. Okay. If any shall be granted genuine, legitimate, logical, they've qualified the grounds also. So you say the grounds that they give is not genuine, it's not legitimate, it's not logical, not justifiable.
And moreover, this extension itself could not have been, Lordship.
Why?
Because, Lordship, it was when the tender itself did not provide for an extension, the agreement could not have extended the period after the tender was already issued, Lordship.
After tender issued, then the agreement will be signed.
Lordship,
where the tender?
Lordship, the tender only the notice, because time and again we have requested them to
see the tender notice. You will not say that extendable line. They will not say that. It's only when you enter the agreement, especially when you come to the bid amount. Where's the tender?
Lordship,
Where's the tender notice?
Common tender notice, page 59. This, Lordship, this short notice inviting tender. Just this, Lordship. We have time and again requested them to give us the detailed tender document or to produce the record. They are not doing it, Lordship. And
now who's appearing for the lessee?
Mr.
Yeah, for 3 revenue stations they're holding the lease. But it's only one.
Only one.
This is a tender for 3 revenue stations.
Lordship, is under this only they have also been appointed. That
so
is
it's
why,
a blanket tender.
Yes,
that's why it's in the agreement will be the most important document.
And in the other under check gates also, it's only 3 years, Lordship. It's only, that is what I'm trying to say, Lordship, that here only for this particular thing, Lordship.
Where it says for 2 years in the notice?
Lordship, it was there in the detailed tender document, Lordship, which because we had submitted, we don't have a copy of it anyway. It's not available online, Lordship.
Is that correct?
It was always for 3 years, Lordship.
What is your submission?
My lord, my submission is that clause 17 very specifically provides, my lord.
That is what. If see the
and
thing
pursuant to that, he filed an application, my lord. The application.
Whatever it is, you come back only to even the law regarding leases or transfer of property, whatever. You are governed by the recitals of your agreement. Is a one-on-one, like divorce, other conditions. So if the recitals provides for that, then where's the scope? And we can't enforce convention.
Lordship, only thing that I'm saying is when the tender stipulated for a certain period, Lordship.
He said that's a convention. But in the agreement is entered into, that was entered at the time of entering of the contract. It's not that. It is not that agreement was made subsequently on the conclusion. This clause.
Lordship, yes.
That is the big difference.
Lordship,
now we can understand, Mr. Deb, suppose at a conclusion of a contract on an application made by the respondent number 6, the contract is extended. But in your case, it's that initial when you signed it in 2022. 21. That clause is already there.
It appears, Lordship, that the standard contract which was made as per the tender condition,
then you file a suit.
Have that clause, Lordship.
Then you file a suit.
That is why only my prayer is let them produce that tender document, Lordship. Everything will be clear from it.
Yes.
What had happened is, Lordship, that 3 years tender was issued. He won the tender. Agreement was supposed to be for 3 years. he himself
2 years,
gave
3 years.
authentication that
Well,
he
he-
give me an extension clause.
At least what he can do is he challenge the clause 17, my lord. Even that is not.
You have not challenged. You have not challenged clause 17.
No, my lord.
I have
Then.
asked for a setting aside of
Oh,
this
I thought that you said you challenged clause 17.
Lordship, I have asked for a setting aside of this entire extension, Lordship, including
Only the extension, not the original agreement, clause 17, my lord.
Then.
Lordship, I have prayed for setting aside the
Then
extension.
you file a
of the
suit
agreement, Lordship.
for
Only my
academic.
purpose
Then you
of
file a
this-
suit for academic purposes with
Lordship,
regard to the status of convention and recitals of agreement.
my only submission is, Lordship, when the tender was a public document, it was for 3 years. Agreement was supposed to be for 3 years. When everything concluded, the agent sent a letter that, see, I want an extension clause incorporated in my agreement.
Where is that is without any basis, my lord. On what
That
basis is
there.
submitted?
It's in the affidavit of the agent that I have myself requested that you put. the
Correct,
extension
Mr.
clause.
Shila, you requested for extension before signing the agreement also.
Yes.
We have requested
Before signing the agreement.
because of the situation that was.
No, I mean before signing the agreement itself, 21.
Yes. No, my lord. No.
Yes.
That's not.
No, how can that be possible? Then how is the agreement signed 21 that clause only exists?
No, my lord. That is a standard agreement. But before the expiry of this original agreement, there was certain situation which.
No, that's not genuine, logical, justifiable. Mr. Deb, we are dismissing your case for you.
Lordship, let them
do what?
Come up with that tender document, Lordship. My entire case rests on that proposition.
We're not going to roving inquiry.
And he's not even an original bidder, my lord. What is his?
You don't original bidder also?
No, my lord.
Who are you?
No, I wanted to call you. I wanted to bid when the tender was supposed to expire.
Oh, even your locus.
Original bidder.
No,
You're not one of the bidders.
no. Originally, I was not a bidder. Then when
Sorry.
I filed an RTI saying that I want to bid. There is no tender. Then they replied, Lordship, with an RTI. saying
So
that we
you're
have already
letting
extended.
these people fire the gun from your shoulder?
Absolutely not, Lordship.
Then what is it? What interest do you have?
I am-
Suppose we set aside this extension. Are you to gain?
Lordship, I am
Will it be
praying
settled with
I
you?
am praying for a no tender. I am not asking them to give it to me.
Yes,
I am asking for a tender, Lordship.
Yes, we'll
My-
dispose it of. The
Allow me
petitioner
to, Lordship, if I may.
allow you to do what?
Kindly give me one day. I'll just take instruction. No, I'll just convey what is falling from the court, and I'll just kindly have it next week, Lordship.
1 day.
1 day is next week.
2 days,
Yes. 2 days is 2 weeks. Yes.
Because
Mr. S. Depp on hearing tentative view expressed by the court prays that he may be allowed to obtain instructions as well to pursue the matter or withdraw it. Yes. Yes, let's on Wednesday. Otherwise,
61.
Because only in this particular agreement only.
you file a suit. Take them to court. Make them with tender evidence.
Wait, please.
Yes, next matter is yours also.
61.
This is altogether different. This is also we are claiming for disability prevention.
Oh.
The Accountant General Lordship had filed this affidavit saying that certain documents are required to be obtained by the petitioner, and that we have obtained subsequently in the independency of the matter, and we have put it on affidavit, Lordship. So, in my humble submission, there is no.
Who's appearing for this? Where's state? Not here.
Adaya used to appear in this case. Adaya is appearing.
How is he? He's recovered.
Still recovery.
Only short issue, Lordship.
Let them see the concerned counsel is not here.
As far as the
Next week will be okay.
Okay.
Yes, as the engaged counsel for the state respondent is not present, just after 1 week. We don't have to hold it also.
Hello, Braj.
Definitely hearing.
So nice.
Huh?
Oh. 63.
Immediately after vacation.
Immediately, Mr. Chanda. Yes.
Immediately after vacation, my lord.
Okay. On appeal, Mr. Chanda lists his matter immediately after vacation.
65.
My lord, same prayer, my lord.
Well, 65 is stay out of it.
Ah,
My lord,
no objection.
My lord, it may be taken up, my lord, immediately after vacation, your lord. I will satisfy your lord. Immediately after vacation.
Well, this is causing a lot of difficulty in the department. Well, he is been reported to parent department. And
Is it a transfer matter?
no, well, he asked for reimbursement to certain trade, my lord. That was rejected. Now, stay was granted on the basis of Manipur High Court order, my lord. The division bench is satisfied that order, my lord.
No, my lord. Again, there was the order, my lord, of interim order. Again, there was the interim order. And I have a very, very good case, my lord. I have a very good case.
Okay, after vacation, first immediately.
And your lordship judgment also covered it.
66.
And interim order to continue, my lord, till then, my lord.
Interim order will
Interim
continue.
Obliged.
Yes, what happened?
Lordship, this,
Lordship, we had
matter
submitted the
about pay overdrawn and pension matters, my lord. So they have submitted the tabulation of how much after retirement.
terminal benefits he is due to get and his pension, monthly pension due. On
But
the
my
last,
contention before this honorable court was, my lord, that the undertaking cannot be executed at this, after his retirement, my lord.
Which undertaking for refund?
Oh yes, pay overdrawn, my lord. It was done
You
after
have authority
decade,
to
my
show
lord.
that.
Yes, I have submitted, my lord. Last occasion I did furnish the Supreme Court judgments.
Where is that? This one, Sir Punjab.
Yes, my lord.
Rafiq Masi case.
Rafiq Masi.
No, on the basis of this judgments, my lord, there are some other subsequent judgments
Which are which?
passed by some high courts, my lord, and even in Madhya Pradesh, a judgment was delivered by the three-bench judgment, my lord. Three-bench judge, my lord. So, in regard to that, my lord, if lordship is pleased to come, page 58, my lord. It talks about the undertaking, my lord.
Where? This is which judgment?
This is judgment of 2024, High Court of Madhya Pradesh, my lord.
Which paragraph?
Paragraph
They might have some other rules here.
26, my lord. So it says the guidelines would indicate that an undertaking has to be furnished
That's
by
what
the...
guidelines are there. We don't have guidelines here, correct?
No, your lordship.
Yes.
But there are those rules, your lordship.
No, just read 26.
Lordship. The guidelines would indicate that an undertaking has to be furnished by the employee to the effect that he will refund the excess payment made to him. It is only on furnishing of such an undertaking the payment towards revision of pay would be made to him. Therefore, this goes to indicate that an undertaking is required to be furnished at the time when the revision of pay has taken place. The same is also reflected in the judgment in the case of Jagdev Singh. Therefore, the undertaking which is being furnished at the time of extending the benefits of revision of pay to an employee is required to be taken note of the indemnity bond in the form of an undertaking furnished at the fact and of service career cannot be said to be an undertaking for which the recovery of excess payment which has been made decades ago could become effective. The judgment of larger bench of the High Court, Honorable Supreme Court in the case of Syed Abdul Qadir.
No, see, now, what is the circumstances for recovery in his case? I've forgotten about the case.
There was an excess payment, your lordship, from
How many years?
since with effect from 2007, your lordship.
2007.
At the time of revision of the pay, your lordship, there was some excess payment given to him and it continued till his retirement. And when the pension papers were being, service book and pension papers were being processed.
What is the extent?
It was about 10 lakhs, your lordship.
10 lakhs.
Now, your lordship, this is actually, I had submitted one of your lordship's judgment where your lordship has, it is a covered case where your lordship has allowed recovery.
No, that is the sign undertaking when? Let us see.
And in this case, your lordship, we have got two undertakings, one given in the year 2009 and one given in 2024, your lordship.
It's not the after
No, it is not that this was the only one, your lordship. In 2009 also, there was an undertaking given. 2009 was when the rule was passed for revision of the pay effective from 1st 2007. So that is when he gave an undertaking that if and when there is any excess payment, he is bound to repay it, your lordship. And Rule 73 of our Meghalaya Civil Service Pension Rules also says, your lordship, that it shall be the duty of every retiring government servant to clear all government dues before the date of his retirement. So we are going by this rule and also by the undertaking given by him.
Where's that where he had signed undertaking 2007?
In our affidavit, Your Lordship. The undertaking is here at page 20, Your Lordship.
20.
Yes, Your Lordship. So next page.
This is 2009.
But see the date, my lord, of this signing.
Which is 2009, 2013.
That is what, my lord.
2009 was the date when the
But the signature-
revision of pay
But the
was
signature
introduced,
shows that
Your
he
Lordship.
has signed it on 2013. How can that be possible, my lord?
That is possible, Your Lordship, because in the department they may have prepared this and got a signature later. And then, Your Lordship, at page 21 also there is another undertaking, but of course this is on 4/4/2024.
That is after his retirement.
He died now, he's still there.
No, he is still alive, Your
Still
Lordship.
alive, my lord.
He says that he didn't give early undertaking.
He has never denied that, Your Lordship.
You know, denied.
He has never denied that.
You're
Your
not
Lordship. And he is neither.
And this revision of pay came into effect 2007.
It is effective from 2007, but it was introduced in 2009, Your Lordship, as per their own writ petition, Your Lordship,
That is
at
my
para
contention
4.
is that, my lord, that the undertaking which was given by the petitioner, my lord, cannot be executed after his retirement, my lord. That is after his decade, my
But
lord.
if it's signed on,
If
But it has
if-
been
if
signed,
it's
Your
not
Lordship. It
by
is
way
not a
of fraud
case that
or
it has not been
misrepresentation,
signed. It is not a case that he has never signed an undertaking. The date may be different, Your Lordship, because the department
that
sometimes
is why
fill
I'm
up the
relying on the
forms.
judgments also, my lord. That undertaking is a force undertaking, my lord.
Then there is no such contention in his writ petition, Your Lordship. At no point of time he has denied that he has signed
At one
the.
of time, we have not even said about undertaking, my lord, in our writ petition. They came up with the undertaking only in the affidavit in opposition, my lord. So
you suppress that also.
They have suppressed it, Your
I'm not aware,
Lordship.
my lord.
They have suppressed it,
retirement
Your
also,
Lordship.
that you signed it, you suppress that fact.
No, my contention is that even if there is an undertaking, my lord.
No, you can't take that. If you have
And
to
it's
take
a
it wrong, you have
contract.
to put
He's
all
bound
the
by
cards
that
on the-
undertaking.
You have to put all the cards on the table, correct? So if you are aware that undertaking has been signed wrongly or rightly or after a time, that you should have placed and to show that the undertaking will not amount to an undertaking. If you want to take benefit of that mercy case, right?
Yes, but
there are four conditions for groups. I mean, for group 3.
Yes, grade 3 employees
for my group three,
impermissible,
yes,
Lord.
not permissible, but will not apply if you have signed undertaking that the pay will be covered. That
No,
also.
that came later, my lord. That judgment.
No, that Jagdeep says no. Whatever it is, we come by what is we're going by the law, right? That's the only thing is. Why do you suppress it?
And they've not filed a rejoinder also, Your Lordship, to our affidavit. And neither have they challenged the rules of 73.
You have not challenged the rules. Forget the rules.
Yes,
But you have not actually contested.
No.
You're not contested.
So, Lordship, my humble submission is that, Your Lordship, in view of the fact that he was put on notice, he has received
But it's
excess
2 dates. Why
payment.
the 2 dates here? That's the only thing that troubles the court. There's not a signature. Can you produce a file?
We can produce a file, but Your Lordship, I assume that it must have been filled up, but it was oversight, it was never taken, his signature was not taken then. Because the rules were introduced in 2009, Your Lordship.
Yes, by who's writing? He's writing only.
This is a signature. He's not denied it, Your Lordship.
Illiterate or illiterate?
There's not a whisper of this.
Illiterate.
Literate, he is a senior Gram Sevak, Your Lordship. Retired as a senior Gram Sevak. And Your Lordship's judgment is very clear, Your Lordship. Badarisha Nonkar versus State of Meghalaya. Where Your Lordship has dealt with all these aspects. Relying on the Supreme.
Oh, yes.
I think I had submitted on the earlier occasion. Also.
The same one you submitted?
Yes,
No,
Your
what
Lordship.
is that?
That's the same one, Your Lordship. And then there's another one.
Oh no, this is here. It's here.
Your Lordship, it's already there. And there is another one of High Court of Punjab and Haryana versus Jagdev Singh and.
What is Chanda Prasad?
Then there is another one, Your Lordship, of
Yes.
Chandi Prasad Uniyal, where at para 14 it says, Your Lordship,
Yeah.
We are concerned with the excess payment of public money, which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor to the recipients. We fail to see why the concept of fraud or misrepresentation is being brought in such a situation. The question to be asked is whether excess money has been paid or not. Maybe due to a bona fide mistake, possibly effecting excess payment of public money by the government officers, maybe due to various reasons like negligence, carelessness, collusion, favoritism, etc., because money in such situation does not belong to the payer or the payee. Situations may also arise where both the payer and the payee are at fault. Then the mistake is mutual. Payments are being effected in many situations without any authority of law, and payments have been received by the recipients also without any authority of law. Any amount paid received without authority of law can always be recovered, barring few exceptions of extreme hardships, but not as a matter of right. In such situations, law implies an obligation on the payee to repay the money, otherwise it would amount to unjust enrichment, Your Lordship. Here, Your Lordship, he has received, it has not been denied. He has given undertaking which has not been denied, Your Lordship. And then now he is bound to repay the money, Your Lordship. And we have initiated this recovery proceedings as per rule, Your Lordship. 73 Rule 73 says that any officer retiring, Your Lordship, is bound to pay whatever he owes to the government. And Your Lordship, he is not going to suffer any hardship because from the...
Now only one thing, see, the money already recovered or no?
Money not yet recovered, Your Lordship. We are in the process when they have filed this case, Your Lordship. In the meantime, Your Lordship, we have also given that his monthly pension is about 46 or 47,000 per month.
How much you plan to recover per month?
We haven't decided. We'll do it over a period of time, Your Lordship, in easy monthly installments.
46,000. So if it takes,
and he is receive a lot of he is going to receive a lot of terminal benefits, about 22 lakhs plus.
So if you take 10,000 a month also,
22 lakhs plus he is getting, Your Lordship.
And that take how many years to clear out your?
It will take a long time, Your Lordship.
It will take around 10 years.
Yes. So, but he is getting terminal benefits to the effect of about 22 lakhs plus.
They could have recovered it then, my lord. But now after retirement, they're coming up with this undertaking saying that they could have not recovered, my lord.
Have you made any statement regard to your financial condition, extreme hardship that you might face?
No, there is nothing as such, Your Lordship.
My lord, because about the bank, we have taken a loan also, my lord. That loan that is accumulating, my lord, the interest rate also. Because of
that loan is not our concern, Your Lordship.
No, because there has been, because he has already retired, my lord.
No.
That is why the
loan you have taken, you're not servicing the loan.
No, because he's not getting pension from where?
Let's see the statement. See, the only consideration we can give is the moment. Since you have not filed a rejoinder, also later you challenge the undertaking, is only on the basis of extreme hardship which you can show. That to recover this
moreover, my lord, he has become
Your Lordship,
deaf,
he is getting 22 lakhs, 36,000.
Whereas gratuity?
All gross total, DCRG he is getting about 10 lakhs, 80,000. Then leave encashment is getting about 8 lakhs 82. Then final GPF is getting 3 lakhs. That statement, Your Lordship, I have given on the last occasion, but I can still give another copy, Your Lordship. He is getting about 22 lakhs plus, Your Lordship.
This is when was it given?
This was given
on the last occasion.
Yeah.
On the last date, I think I had given, Your Lordship.
This has been drawn by him.
3 lakhs.
Has been drawn. 22 lakhs been drawn.
No, not yet, my lord.
Plus leave encashment
No,
plus
that has
final
not been drawn.
GPF.
No, that has not been drawn. As per their statement, my lord, if Lordship sees the serial number 3, they said that final GPF has been withdrawn.
Yes.
Yes. That is there. But 2236 has not been drawn, my lord.
So you have a good question.
Yes, he's getting about 22 lakhs something, Your Lordship. And then his monthly pension is also
I'll leave it to your discretion, my lord. But my contention, my lord, just...
See, Mr. The moment we have
it is government money, Your Lordship.
Proper pleadings, very difficult for the court in such cases. Understand? You have to make out extreme circumstances which will allow, like, exercise discretionary power with this court. Not like, on a simple formula. Or like, because the things that you've signed, rightly or wrongly, when do you retire? In 24?
24. February 24 he is retired.
But that is
last undertaking is signed on?
24. After his retirement, my lord. That is why, my lord, I was relying on the submission, I was relying on the Supreme Court judgment, my lord. It says that after retirement,
That is a Madhya Pradesh judgment.
But that will not apply to you because you have two undertakings.
No, even that after decade, my lord, that was signed in the year 2000.
But that was at the time the scheme is revision.
Supreme Court says what?
The effect.
Supreme Court says that suppose a pay revision had come into effect, suppose we see in 2005, right? And then you were paid at the wrong fixation
Excess
of your pay,
payment,
right? Then suddenly, like in the year, like before he retired, they say, "Oh, sorry, we paid excess. We have to recover." In those circumstances, it's a decadal, like where the pay revision had come to with. Then they'll not be entitled to recover. But in your case, if the notification issued 2009, making the pay revision effective 2007, and you signed the undertaking 2009, that means from initial date implementation or notification of the revised pay, you already know knowledge, and you sign undertaking that okay, there's a revised pay that's been put into place. If I'm drawing extra, then I will be liable to recovery from my salary. That's all.
And
then you sign that once, he signed it twice, right? So you understand where you stand.
And he's not denied that, Your Lordship.
You're not denied also, and you have not even filed any rebuttal or rejoinder anything to the
undertaking.
So that undertaking is there. Then the knowledge of the pay revision, rightly or wrongly, is there, right?
Yes.
So it's not a question of like applying Supreme Court decision to say you're going to recover decadal growth or decadal, old pay revision. Suppose in 2006 and suddenly we say, Mr. Moment, sorry, we paid wrong. Then there's not possible.
Planning to recover it from 2007, my lord.
Because the excess payment was made with effect from then.
2007 and you signed 2009.
I'll
It's
leave
not,
it to your
a,
discretion,
it's not a question. Not leave to court's discretion. That's a very
That is very unfair.
That is a very what do you call it? We're trying to help you.
Lordship.
If you go to discretion, we dismiss it.
I'll leave it to your discretion, my lord. Only continue that at least my submission may be recorded because I am relying on some Supreme Court, some judgment, my lord. If that may be recorded, because that judgment,
that judgment does not apply squarely to our case. To our case.
That you can't say.
Yes.
That
Where's
is-
the judgment?
There is judgment I've been relying, my lord.
The first company pleadings where you express hardship. Where is it? Oh, we said about undertaking.
Yes.
Where is that? Company writ petition.
He's talking about mental harassment and
No.
Para 17, my lord.
I'm talking about extreme financial hardship. Where the one written about a loan?
Para 17, my lord.
No. Where you written about? Where you said I've taken a loan?
Yeah, my lord. Para 17, 18 was there, my lord. Paragraph 17, my lord.
and the loan must have taken long ago, Your Lordship.
Doesn't matter.
That finally the petitioner again submitted another representation to the respondent to recall the order of recovery of alleged overdrawn salary and to expedite the pension and other terminal benefits due to the petitioner, which also of the date thereby causing immense hardship to the petitioner and his family, my lord. And that due to non-releasing of the pension and other terminal retirement benefits, the petitioner could not repay the loan amount of rupees 10 lakhs, which was taken as a loan from the State Bank of India. The branch manager of the SBI issued a demand notice on 2 occasions for default in payment of the loan amount with interest, which had to be faced by the petitioner for no fault of his and the liability along
There
with
were 2 loans or 1 loan?
One loan,
One
Your
loan.
Lordship.
So this is 410. What first one is 8.
8 and 1 is.
So you paid some amount. That means.
Yes, my lord.
What's the status of the loan now?
Now it's still pending, my lord. The loan has not been able to pay because of the financial condition, my lord. And he has to go for further treatment also, my lord. But that cannot be done. I've also enclosed the medical certificate also, my lord, here.
Yes. I think we'll recover half only.
Your Lordship, let him pay by installment. Your
Installment,
Lordship.
5 lakhs you
50%
pay.
can be recovered from the terminal benefits he's getting,
Yes, 5
and the
lakhs
rest we
recover,
will
that's all.
take
The rest you recover,
take it by
you release his pension.
installments. But the
I think that's the only way. We just
50% of the amount may be allowed to be recovered
yes, 50%,
from his
10
terminal
lakhs.
benefits, and thereafter your lordship will take it by
At the rate
installments.
of 5 lakhs, what per month? How much from your pension? 46 you're getting. Take down, yes. Excuse me. Where's the petition? The brief facts are that the petitioner had served as a Gram Sevak in the office of the Block Development Officer from a Samanda Development Block, East Garo Hills District, on being appointed on 12/03/1984. Stop. You retired as senior Gram Sabha.
Yes. Senior Gram Sabha.
The petitioner, after in the course of his service, was promoted to the post of senior Gram Sabha and retired from the said post on 29/2/2024. Stop. When the matter came for clearing of his terminal benefits, it was put to the knowledge of the petitioner that we put a white letter dated 25/24 that his salary had been overdrawn, which was to be recovered before the pension and other terminal benefits were processed by the respondents. Stop. The petitioner thereafter had preferred representations, but on being aggrieved as to the inaction is before this court by way of the instant writ petition. So, next paragraph, Mr. E.G. Mohan, learned counsel for the petitioner, has submitted that the recovery of rupees 10,73,496 from the terminal retirement benefits of the petitioner is unsustainable, inasmuch as grounds. Inasmuch as it is not the fault of the petitioner that excess amount had been paid. Had been allowed. So, he further submits that to recover the amount from the petitioner at this stage would be causing gross injustice, as he has availed of a loan from the State Bank of India and is also suffering from an ailment for which the petitioner requires treatment which is not available in the place where he is residing. Stop. Learned counsel has drawn attention of this court to where that's State Bank. Attention of this court to annexure to the annexures appended to the petition.
15, annexure 15.
have drawn attention of this court to lecture 15, which is a letter dated 8/8/2024, and lecture 15A, which is letter dated 4/10/24, which evidences the outstanding demand of rupees 16 lakhs 169054 plus interest being made from the petitioner. Further, the learned counsel has also referred to the medical certificate. What is
This medical certificate, Manu.
medical certificate? Where the patient has been advised to proceed for a treatment. Stop. He submits that though the petitioner might have executed an undertaking in the prescribed form with regard to allowing the recovery of an excess amount, at this late stage after his retirement, firstly facing extreme financial hardship and also health condition, this court may be pleased to pass appropriate orders to exempt the petitioner from these recovery
proceedings.
Yes, from recovery, and to direct for the release of his terminal benefits and pension also. Pension you're not getting till now?
No.
Pension till now, which he submits, has not yet been released. MS, should you refer the judgment you place or not necessary?
Up to you, Lordship, but
take down MS Yang 11 EAG with so and so. In reply, submitted that the recovery sought to be made is as per due procedure and is not one where, and is not an action, and is not, and can't be said to be arbitrary or discriminatory in any manner. Stop. Learned senior counsel has submitted that firstly, the writ petitioner has executed an undertaking in the prescribed form. In this context, he informed and submits that the pay revision had been made effective from the year 2007, and the first undertaking made in 2009 has not been refuted by the writ petitioner. So also the second undertaking executed in 2024. Stop. She further submits that as per Rule 73 of the Meghalaya Civil Service Pension Rules,
Yes,
right? The government reserves the right and is a liability of every retiring government servant to clear all government dues for his retirement, and when the same not possible out of the gratuity payable, the same will be recoverable. Stop. She submits that this rule also having not been challenged, and the petitioner having put to notice with regard to discrepancy in pay, if any, which will be recoverable, no case has been made out for interference by this court. In this context, the learned counsel has also referred to judgment passed by this court in the case of so and so. WCN, the judgment was court dated 15/11/2022 in the case of so and so. In WPC, sorry, 255/2020. So, stop now, next paragraph. This court has heard and consulted the parties and also peruse and materials on record. A fact that the fact that excess amounts are recoverable from government employees as per the due process of law Tom first of all, I've heard something on First thing that I've heard, so having heard, lalu pas sedang paragraf ni, and notes that the recovery of overdrawn pay in terms of Rule 73 indicates that the government servants duty bound to clear all government dues. Give the same, and if the dues are not cleared, the same shall be recoverable from his gratuity or other terminal benefits. Stops. Though it has also been, this court also has not lost sight. This court also has taken into consideration the judgment of that's Rafiq Masih citation.
2015 for SCC 334.
The judgment of State of Punjab and others versus Rafiq Masih bracket whitewasher and others reported in 2015 for SCC 334 and also subsequent judgment of High Court of Punjab, Haryana and others versus Jagdeep Singh GADDV Singh reported in 2016-14 SCC 267. Reading of these two judgments, including the exception given Rafiq Masih, the condition precedent given in Rafiq Masih shows that in the event an officer to whom payment was made was clearly put on notice, the said officer or government employee will be bound by the undertaking. So, well, the judgment you gave, as such, in the present case, in the circumstance of the present case would show that as observed, the spelling would show that as observed earlier, in the present case, it has not been disputed that the petitioner had been put to notice as to recovery, and as such, the order for recovery cannot be said to be illegal or irregular in any manner. However, the only consideration that is for this court is the extreme financial hardship that the petitioner is facing due to not-use of pensions, which has been compounded with the loan that's been availed and also his medical condition. stop in this extreme.
The only consideration before this court is the extreme financial hardship that the petitioner is facing due to the release of pension, compounded with the loan that has been availed and also his medical condition.
Yes, at this juncture, it's useful to refer to the judgment of the Supreme Court in the case of this one, Chandra Prasad Unial, reported in 2012, 8 SCC 417. Wherein at para 14 it has been held as follows. The quote. Stop. A perusal of the above quoted paragraph shows that any amount paid or received without authority of law can always be recovered, barring few exceptions of extreme hardship, but not as a matter of right. Stop. In the considered view of this court, though the recovery proceedings are not liable to be interfered with in consideration of the extreme financial hardship and other circumstances with petitioner, to balance the equities, it is directed that only 50% of the amount recoverable shall be.
Your Lordship, praise that, Your Lordship, the entire amount will be recovered, but 50% will be recovered now when we are releasing his terminal benefits, and the rest in installments. Then 75%, Your Lordship.
Only 50% of the amount
that will be
shall be recovered. So from the terminal benefits of the writ petitioner. Stop. It is reiterated that this order has been passed as considering the circumstances of the case itself and shall not serve as a precedent in other matters. Yes. Matter on as discussed above, as observed above, the matter stands closed and disposed of. See, with the woman mercy petition